Hello, hello, and welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case. We are following along with what is going on with Indiana and Richard Allen, and also with the lawyers involved and all the unnecessary drama that's been going on in this particular case. But this case, this episode, we're going to go over the motion to suppress statements that the defense just filed on the 11th. So that was this week. What is that? Wednesday, Thursday? I don't know. One of those days. So they filed this motion to suppress statements. So we'll talk about that in one second. We'll read that in one second. And then they also filed a memorandum of law in support of the motion to suppress. So we'll go through that. So that is going to be this episode. Going to be interesting. Before we dive in, please hit the like button and subscribe if you're not already a subscriber. I do updates every week on the Delphi case, sometimes multiple updates because there's so much going on. So I like to keep it weekly, but if there are a lot of filings during the week, then I will try to get in multiple episodes through the week to keep you guys informed. So here we go. Let's begin with the motion to suppress statements. The defendant, Richard M. Allen, by counsel Bradley A. Rosie, respectfully requests that this court suppress as evidence in this cause, any and all oral and written communications, confessions, statements, or admissions alleged to have been made by defendant Allen during his pre-trial detention in this cause. In support of this motion, defendant Allen states the following. 1. Defendant Allen is charged with 2 counts of felony unaliving, counts 1 and 2, and 2 counts of unaliving, counts 3 and 4. So during the course of defendant Allen's pretrial detention, it is alleged that defendant Allen communicated incriminating statements to state actors and or their agents, all of which the state of Indiana intends to present to a jury at the trial in this cause. The statements were involuntary and thus obtained in violation of the following: A, his First Amendment, B, his Sixth Amendment rights, C, his Fourth Amendment rights, and D, Article 1, Sections 12, 13, and 14 of the Indiana Constitution. So 3 amendments, 3 of his constitutional rights were violated, along with several Indiana constitutional violations. Number 4, the statements sought to be suppressed were obtained as a result of psychological and mental coercion illegally directed against the defendant, and such statements were therefore involuntarily made. 5, the statements sought to be suppressed were obtained as a result of physical coercion illegally directed against the defendant, and such statements were therefore involuntarily given. Therefore, any and all communications, confessions, statements, or admissions alleged to have been offered up by defendant Allen were elicited in violation of his constitutional rights under the 5th, 6th, and 14th Amendments to the Constitution of the United States, and his rights under Article 1, 12, 13, and 14 of the Indiana Constitution. Wherefore, defendant Allen, by counsel, respectfully requests this court: 1. Conduct a pre-trial hearing to determine if the statements alleged to have been given were voluntary in nature, and 2. Suppress as evidence in this cause any and all communications, confessions, statements, or admissions, written or oral, written by him subsequent to his arrest in this cause. And that is signed by Bradley A. Rosie, attorney for defendant. Interesting. I have a feeling Judge Gull will deny it on his face without any hearing, but here we go. Memorandum of law in support of defendant Allen's motion to suppress. Facts. Defendant Allen was arrested on October of 2022 and immediately detained in the Carroll County Jail. Allen was thereafter transferred to the White County Jail and ultimately charged with 2 counts of felony unaliving. The charges were lodged against him on October 28th, 2022. On November 3rd, 2023, the Carroll County Sheriff petitioned the court for an order transferring jurisdiction of Allen's custody from the Carroll County Sheriff. So the sheriff put in the petition. I'm just curious as to who made it. Okay, so the sheriff petitioned the court to move Allen's custody from his possession to the Indiana Department of Corrections on the same day and without the formality of a hearing on the sheriff's request. Judge Benjamin Diener signed an order, a safekeeping order, transferring Allen's custody to the IDOC, without Allen or his legal representatives having any input into his pretrial detainment. At the time the court signed the safekeeping order, Allen had yet to be appointed counsel. In fact, Allen's court appointed the public defenders Rosie and Baldwin did not enter their appearances until November 14th, 2022, and therefore Allen had no input as to his pretrial detention circumstances. The record should also reflect that the safekeeping order and all other exhibits referenced herein have been personally served on the court in the form of a supplemental appendix. Okay. So basically he was moved, the safekeeping order to change his housing from the sheriff's, from jail, which is where pretrial detainees are held, but they moved him to the IDOC, which then shipped him off to the Westville Correctional Facility and placed in a maximum security segregation until referred to by prison officials as WCU. So the Westville Correctional Facility, also known as WCU, a maximum security prison, and he is placed in segregation. Think about that. This guy isn't even convicted yet of the crimes. He's charged, but he's awaiting trial. He's still supposed to be presumed innocent, and that's where they have him, in a high maximum security prison in segregation at Westville Correctional Facility. Well, he's not there at Westville anymore. He's at Wabash now. So the record suggests that just prior to his transfer to WCU, Allen may have made a brief stop at the Reception Diagnostic Center where some sort of intake procedure may have taken place, but it does not appear that Allen underwent any formal mental health assessment or testing to establish a baseline in terms of his mental health records or history. From approximately November 1st, 2022 through December of 2023, Allen remained incarcerated in the WCU. Allen's attorneys are unaware of any other pretrial detainee that has ever been housed in the WCU in the history of the facility. So no pretrial detainees have ever been held there. So this is just unprecedented. And most certainly not in the 5 or so years preceding his placement. So let's read this. Warden John Gallipo was deposed by the defense on Friday, March 22nd, 2024, where he acknowledged he had worked at the IDOC for 28 years and was the warden at Westville for approximately 5 years leading up to Allen's placement. Warden Gallipo acknowledged that during his entire tenure, he was unaware of any other circumstances involving the pretrial detainee of a man who had not yet been convicted of a crime. So that is from his testimony or deposition, sorry. Well, it's the same thing, basically. It holds the same weight. All right, so his deposition, he said no one in his recent memory. So Allen's attorneys have conducted depositions, watched video from Allen's cell and other video from within the prison, reviewed prison records regarding Allen's detention, reviewed Allen's medical and psychiatric records, and listened to audio interviews of prison inmates and guards conducted by law enforcement officials. Through this process, Alan's attorneys have learned that Alan has been accused of making incriminating statements to both inmates and guards. Nearly all of these statements appear to have occurred between mid-March of 2023 and June of 2023. During this time frame, there also exists medical psychiatric records consisting that Alan was in a state of psychosis. Alan's defense team has learned that Alan was not only detained in an isolation cell in WCU, but that prison officials close to post inmates at Alan's cell door prison officials chose to post inmates at Alan's cell door and required the inmates to keep logs of all of Alan's actions, statements, and behaviors. Could you even imagine that if you were in Alan's shoes? This appears to have occurred during all hours of the day and continued over the course of much of Alan's stay in the WCU. These inmates, all of whom are convicted felons, were not only actively engaged in surveilling Alan's activities, but were also communicating with him from time to time. Alan's attorneys have also learned that at some point in early April of 2023, prison officials deliberately pulled the inmates from Alan's cell door and replaced them with prison guards. Alan's attorneys have learned that this appears to have been prompted by an inmate or inmates engaging Alan regarding his pending charges and communicating Alan's thoughts and words to the families of those inmates, thereby violating any sense of confidentiality that might exist within the walls of the penitentiary. Most notably, Alan's living circumstances within the prison appear to have been designed, whether intentionally or unintentionally, to expose him to some of the harshest conditions that even the most heinous of convicted offenders would not endure. The coercive environment was initially the product of Alan's being detained in an observation cell used for convicted inmates with self-deletion ideations. This single cell located in a pod is one of the approximately 60 individual segregation cells, all containing felons convicted of crimes such as burglary, robbery, child M, each and every, not that that's funny, but just that I have to use these stupid code words. So, not funny at all. The acts upon a child that would severely traumatize them and end their lives. Not funny. All right, so each and every one of these inmates had the ability to communicate with Alan by yelling at him at all hours of the day and night, and by chastising him every time he was removed from his cell for purposes of recreation, showering, or other administrative reasons. So if he was just leaving to go shower, these inmates would be yelling and screaming at him and chastising him, like, how dare you go take a shower? How dare you leave your cell? I don't know, but that's what it appears they were doing. Alan's attorneys have learned that he was referred to as a BY ender, a baby ender, and that he was the target of other similar accusations during his stay. Prison records reflect that Alan was placed on self-deletion watch during the majority of his stay at the WCU, including upon his initial detention in November of 2022. This occurred despite the fact there were no underlying findings to suggest he was in that mindset. Alan's designation as a self-deleter subjected him to even harsher circumstances than those of other offenders on the unit. For example, Alan's bed consisted of a metal plate with a thin mattress, all of which was just a few inches from the concrete floor. Alan was issued an anti-self-deletion smock, which covered his body no better than that of a garment of a caveman. Alan's food was served to him through a cuff portal, and his dining habits involved him sitting on a bed or on the floor, as his cell was not equipped with a table or a chair that would otherwise serve even as a rudimentary dining arrangement. They basically treat him like an animal. Alan's cell also contained a steel toilet and a sink, both in direct line of sight of the inmates and guards assigned to his surveil. The toilet bowl was located approximately 24 inches from his bed. Alan's attorneys learned that Alan was not only under constant surveillance, but that the lights remained on in his cell for many days and nights. That's torture. That is considered torture in other countries, or, that you do that to prisoners of war and things like that. It's torture. Not getting your sleep and all that. It is also true, and even with the lights on, unless you block something to cover your eyes, you still absorb that light. Your eyes do, so you don't get as deep of a sleep. So it is a torture technique that keeps you from sleeping properly and makes you want to, because you're not getting enough sleep, or you're not getting the deep sleep that you need, the restful sleep that you need. You are prone to false confessions and things like that. And it's being suggestible. You're prone to being manipulated and having your ideas and thoughts suggestible. So Alan's food was served to him through the cuff of the door. His cell contained a single toilet. The toilet bowl was located approximately 24 inches from his bed. Alan's attorneys learned that Alan was not only under constant surveillance, but that the lights remained on. It was also true that due to his designation as someone who would self-delete, he was afforded less or no recreation time and less of an opportunity for showers. So he wasn't taken out of his cell as often. In essence, his designation was the cause for the removal of additional privileges, to the extent of the word privilege even applies, like, being able to take a shower is a privilege in jail, which in turn further fostered an environment that led to the deterioration of Alan's mental and physical health. Alan's intake records with the DOC reflect that he was 5'5" tall and 175 pounds at admission in November. His weight by April the next year had dropped below 135. That is crazy that he lost that much weight. In all, for nearly 13 months, my brain and my tongue don't align. In all, for nearly 13 months at the WCU, Alan was deprived of any social interaction, very little to no privacy, little recreation time, and was left to entertain himself in his segregation cell. But also he was being monitored the entire time and couldn't even go to the bathroom without people watching him. Unfortunately, Alan's unusual detention circumstances would extend beyond the door of his isolation cell. Whenever Alan was removed from the confines of his 12-by-8 steel and concrete box, aka cell, he was shackled with ankle cuffs, a belly chain, box cuffs on his hands, and guided around by guards with a lead, or what most people would call a leash, treating him like an animal. As if this restriction of his basic freedom of movement was not enough, prison officials assigned a videographer to Alan to record his movements around the prison, including where he would meet with his lawyers. There's no excuse for any of this. I don't even understand why they would do this. There's no excuse. Even if the man is guilty, you don't treat him like this. It's disgusting. You're no better than the people that actually ended the lives of Abby and Libby, because you are intentionally torturing someone. prison guards and Judge Gull and all the rest. All right, that message is for you, not the innocent people that are watching my stream. Sorry. All right, so as if this restriction of his basic freedom of movement was not enough, I read that. Okay, so during all the meetings between Alan and his attorneys, he remained shackled, as referenced above, without like movement of his hands. So his hands would be probably like this. You couldn't barely move, and he's got it around his waist and his feet. He's shackled. You can't even like take a sip of water like that. All right, so during all of the meetings, he was shackled, making simple tasks difficult, such as taking a drink of water from a water bottle. Alan would not be able to communicate as much as hand gestures due to his shackled state. During other meetings, prison officials placed a video camera outside of a room in the visitation room, or outside of the window of the visitation room, and required Alan to sit on a hard plastic chair directly in line with the video camera, which was less than 10 feet away. And his attorneys, I believe, were like 12 feet away or something like that. All right, so you would have to yell in order to hear one another. You couldn't get up. You couldn't approach the defendant in any way, the attorneys. Like, how can you even that's totally illegal for them to be recording their conversations or eavesdropping even. They should be in privacy. Alan's highly usual detention circumstances extend even to his visits with his wife. During one visit, Alan was transported outside of the WCU to a building reserved for visitation for those inmates in general population. Alan, again, was shackled and confined during a transport and ultimately re-robed into a green jumpsuit before seeing his wife. He was, however, unshackled during the visit. At least they gave him that. His embrace with his wife was controlled by prison protocol, which permitted only a few brief seconds of contact, despite the fact that Alan had not seen his wife for the better part of 6 months. Alan was required to sit on the opposite side of the table from his wife and had 2 prison guards stationed within earshot of each of his table. Of each of them. What? Within earshot of each end of his table. Sorry, I'm starting to feel like a headache and words are hurting. All right, so there was a prison guard stationed within earshot of at each end of his table. They were left with absolutely no privacy. The room was completely empty, except for his lawyers and a few other prison guards who were also stationed within the building. This provided no background noise whatsoever, which might offer up some aspect of privacy as he and his wife tried to communicate. So they may have purposely put him in a very quiet section of the prison so that there would be no background noise to drown out the conversation so that the guards could hear very clearly what was being said. And his restrictions did not end there. Alan and his wife were also denied the simple concession of getting a drink of water during his visit, despite the fact that there were a number of vending machines and a water fountain within 10 to 20 feet from his table. And that was from deposition of Gallipo. Alan's universal detention involves... I just said universal. No. Alan's unusual detention involves an even stranger set of circumstances. During the course of their representation of Alan, his attorneys discovered the existence of dozens and dozens of police reports, audio interviews, and other investigative findings that centered on a group of suspects associated with pagan Norse spiritual religious practices. These suspects considered themselves Odinists, all of which were referenced in the Franks motion and memorandum and second Franks motion and memorandum previously filed with this court. And I have done videos on all of the motions, the Franks motions. If you have not seen them, I can link I created a playlist just for the Frank's motions. So I put, I'll link the playlist to this video. So in case you guys have not seen it, or would like a refresh. Where was I? Previously filed in the court, right? Okay. So Allen incorporates herein the details referenced in the Frank's filings rather than restating the lengthy details in this memorandum. Allen's lawyers also discovered that at least 2 guards assigned to his pod and or his movements around the facility also held themselves out to be affiliated with the pagan Norse god known as Odin. And that, my friends, is Odinism. What we've been talking about ever since the very first Frank's memorandum came out in September of last year. So the guards proudly displayed their Odinistic beliefs on their own prison uniforms, despite the fact that such a display was in direct violation of their uniform policy. And on at least one occasion, one of these guards tased Allen after he was placed into his secured 8x12 cell. So why would you tase him after he was already secured in his cell? Because Allen refused to remove his hands from the cuff port in the door of his cell, a cuff port that is barely large enough through which to slide a meal tray. Allen posed absolutely no risk to anyone at the time he was tased. Allen had also battled depression throughout most of his adult life. He was medicated over the course of his life and, in fact, had sought out therapeutic resources to treat and manage his depression. Oh, I missed that one. The facts and circumstances surround the possibility that these individuals that we talked about before, otherwise known as Odinists, are specifically referenced in the Frank's motion and memo filed on September 18th, 2023. And now this one that we just read. Through independent neuropsychological evaluation dated 3/31/24 offered up to the court in the appendix form. So that's coming from, he was medicated over the course of his life and in fact had sought out therapeutic resources to treat and manage his depression. The IDOC gave very little consideration to Allen's condition at this time of his intake and initial incarceration in the WCU, especially given the unusual circumstances in which he was detained. So they did not give any real consideration to the fact that Allen has had depression in his past, and he's battled depression and I believe wasn't he in the military too, so he might have some PTSD as well, and I'm sure he's got PTSD now from what he's going through. So I'm sure there's a lot of things going on mentally in his mind, if any of these things are true. Any of the little things. Any of them. But add them all up, and this is horrific, and this guy deserves millions upon millions of dollars from the city of town of Delphi, in my opinion. So the IDOC gave very little consideration to his previous health conditions, his intake, and his initial incarceration, especially given the unusual circumstances in which he was detained. It is also believed that Allen's medications were administered in a less than fashion, which, oh my God, can screw you up. Because of my fibromyalgia, my ankylosing spondylitis, and all the fun stuff that comes with it, I am on Lyrica, which is specifically it changes your neural pathways. So it's similar in what it does in regards to like a Lexapro, which I am also on, which is for, treatment of depression, anxiety. I have really bad anxiety, things like that. So all of that combined. And if you are not consistent, like I take both of those, and if I'm not consistent with either one of them, oh my God, withdrawals are for real. So bad and serious. Like one dose you miss and you can have serious withdrawals. It can mess you up. It's not fun. So if they're not being consistent with medication for depression or anxiety, he's definitely having ups and downs with it, and PTSD, serious anxiety. I feel that because I've been there with the inconsistent medication. So that's unfortunate, and you get yet another thing that poor Richard Allen has to deal with. So if they were done in a less so his medications were given in a less than consistent fashion while he was in the unit, all of which would have contributed to his inability to endure his living environment during his pre-trial detention at the WCU. The issue is this case. In this case is whether the state violated Allen's Fifth and Sixth Amendment rights and federal and state due process rights by detaining him in solitary confinement in a maximum security prison segregation unit while he was awaiting trial. Allen's statements were involuntary and should be suppressed. Rule: coercive police activity is a necessary predicate to a finding that a confession is involuntary within the meaning of the Due Process Clause, and that's according to Colorado versus Connolly. However, coercive police activity is not a necessary prerequisite to challenge the voluntariness of a defendant's statement under Article 1, Section 14 of the Indiana Constitution, as there may be other elements that would tend to support a finding of involuntariness. The proper standards under the Indiana Constitution is whether the confession was freely self-determined and the product of a rational intellect and a free will. Thus, courts look to the totality of the circumstances to determine if the confession was voluntary, taking into account many factors, including 1, whether the statement was made under a court order, 2, use of police trickery, 3, threats of promises by police, 4, defendant's race, age, or disability, 5, length of detention, C, physical coercion, and 7, illegal police practices. Analysis: notwithstanding the lower standard for showing involuntariness set by the Indiana Constitution, it is indisputable that Allen's detention circumstances were manufactured by the Carroll County Sheriff purposefully. Not just that they were done, but they were done with intention and without the existence of any sense of due process, as the court assigned the safekeeping order without requiring the state to establish the burden of proof required by the statute. But this was just the beginning. Allen was then shipped off to WCU and immediately placed on self-deletion watch in a detention cell where he had little to no accommodations, not even those offered up to the other 2,000 convicted inmates housed across the prison yard. So even with looking at everything that all the treatment that he has endured, not one of the 2,000 convicted inmates have been given that same treatment. They're being given far better treatment than what Allen is receiving. Almost simultaneously with Allen's isolation from human contact, prison companions were placed at his doorstep and tasked with the duty of reporting his every move and recording his every word. The companions appear to have gone above and beyond this duty by communicating with Allen about his case and even praying with him as he struggled to withstand the rigors of his incarceration. Their mere presence at his doorstep is akin to Messiah versus United States, where police obtained incriminating statements from a jailhouse informant who engaged the defendant in a conversation and developed a relationship of trust and confidence with the defendant such that he revealed incriminating information about the charged crime when counsel was not present. The court held that this was improper and suppressed the statements. This trial court should do the same. The trial court's decision regarding admissibility of a confession and incriminating statement is controlled by determining, from the totality of the circumstances, whether the statement was given voluntarily rather than induced through violence, threats, coercion, or other improper influence so as to overcome the defendant's free will. Standard indicators for voluntariness include whether the confession was freely self-determined, the product of a rational intellect and free will, without compulsion or inducement of any sort, and whether the accused's will was overborne. Here, Alan's free will was overcome by the forces of his environment, all of which were placed upon him by the government and its actors. Damn. Alan, a man with bona fide pre-existing mental health conditions, was detained in an isolation cell, entirely isolated from any sense of meaningful human contact, and then offered up the most basic amenities of life through a cuff porthole in his door. He was reduced to sleeping on a mattress that was placed on top of a steel plate just a few inches from the floor. The same mattress and floor also doubled as his dining table because his cell also had no such accommodation. His attire was reduced to nothing but a mere suicide smock covering only a portion of his body. Alan's healthiest accommodations came in the form of recreation time, not to exceed 4 hours per week. In this space, there was not enough room to jog or run, only an exercise bike and a pull-up bar. Alan's other accommodation would have been a window slit that was inside his cell. Wow, that's not an accommodation. I mean, it is, but it's not. It is for a prisoner who has nothing else. Then it seems like an accommodation. His view of anything outside of the boundaries of the penitentiary would have been impaired by the rusty chain mail and razor wire of at least 2 separate fences between him and any sense of freedom. So he doesn't even have a clear vision of the outdoors because it's behind chain link fences and razor wire. To the extent Alan was ever allowed to be removed from his cell, he was shackled at the ankles, wrists, further contained by a belly chain and cuff port, and guided around the prison on a leash. All ideal ways to confine and control the movements of a convicted killer or some other convict who, in addition to his conviction, posed a threat to himself or the prison staff. Alan, at 5 feet 5 inches tall and 173 pounds, soaking wet when he came in, and with not one single criminal conviction on his rap sheet, met none of those conditions. And we go down to 6. It's just talking about his physical appearance. He was down to, on 11/8/2022, he was down to, on 11/8/2022, he was 173 pounds, but on record, on 8/3/2023, he was 130 pounds. Holy crap, that's teeny tiny. All right, so wait, where was it? All right, I missed a spot. As if this treatment wasn't enough, Alan was forced to endure the intimacies of his restraint systems even while he was meeting with the court-appointed lawyers inside the confines of a maximum security segregation unit located inside of the Westville Correctional Facility. And you're supposed to be, like most lawyers will tell you, they rarely meet with their clients who are like shackled. They usually are just face-to-face in a room, handcuffed. You're their lawyer. You're supposed to be helping them. It's not likely that they're going to hurt you, even if they are guilty of the crime. So, all right. So, and to add insult to injury, Alan's meetings with his attorneys occurred while he had a video camera aimed at his face, recording sessions that should have been afforded to the most private of environments so as to protect the relationship between attorney and client. All of this offered while Alan's medications were being adjusted by the prison medical team, the combination of which factors reduced him to nothing more than a human experiment. Allen's free will was overcome. Under the Indiana Constitution, the voluntariness of a confession must be proved beyond a reasonable doubt, and in reviewing voluntariness, the courts look at the totality of circumstances, reviewing all of the evidence in the record rather than focusing only on the evidence supporting the findings of voluntariness. Under the U.S. Constitution, the prosecution only has to prove by a preponderance of the evidence that the confession was voluntary. As explained below, the state cannot meet its burden of showing voluntariness here. Even applying the lower standard of preponderance, the federal courts have a long history of regulating the admission of confessions that have been a product of state actions that exploits the weak and compromised through interrogatory and custodial processes. Sorry, I got an itch on my neck. In Blackburn versus the state of Alabama, the United States Supreme Court noted that it had recognized that coercion can be mental as well as physical, and that the BLOOD of that accused is not the only hallmark of an unconstitutional inquisition. A number of cases have demonstrated, if demonstration were needed, that the efficiency of the rack and the thumb screw can be matched, given the proper subject, by more sophisticated modes of persuasion. The efficiency of the rack and the thumb screw, which are devices of torture from the medieval times. Well, I don't know if they're all from the medieval times, but you know what I'm saying. They're ancient device techniques, can be matched to more sophisticated modes of persuasion. A prolonged interrogation of an accused who is ignorant of his rights and who has been cut off from the moral support of friends and relatives is not infrequently an effective technique of terror. Thus, the range of inquiry in this type of case must be broad, and the court has insisted that the judgment in each instance be based upon consideration of totality of the circumstances. Allen's case falls within these federal parameters. In Blackburn, the defendant had a documented history of mental illness, having served in the military, which ultimately resulted in his discharge. Okay, so Blackburn was, that's where I heard the serving in the military. Sorry, it was not Richard Allen, but he definitely, I'm sure, has PTSD from what he's going through now, if he didn't already have PTSD from something else in his life. Anyways, so in Blackburn, the defendant had a documented history of mental illness, having served in the military, which ultimately resulted in his discharge because of a medical finding that he suffered from some form of psychosis. He was in the process of being treated in the days and weeks leading up to the commission of the crime and his ultimate apprehension. After enduring an 8 to 10 hour interrogation, Blackburn was given a prepared written statement with admissions offered up by him in the course of the interrogation, and he ultimately signed the witness statement 2 days later. And it's baffling that this happens, but it happens. So people give false confessions all the time, and this is just proof, that this happens in the court system, and they have to relitigate these things, and it's clogging up the appeals constantly, and it's talked about over and over again because it's a consistent issue that keeps happening in our judicial system. All right, so after and during that, he gave the statement and also provided or signed it 2 days later. Here, in this case with Richard Allen, he endured a longer, more sustained form of interrogation, one that lasted more than 5 months before he had finally broken. Already suffering from a bona fide mental health disorder and then having been cut off from the moral support of his wife, mother, and daughter, Allen was weakened to the point where he slipped into a state of psychosis plagued with grossly disorganized, delusional, paranoid, and highly dysfunctional behavior. These behaviors were manifested through verbal confessions that he may have been drugged, verbal confessions to the double homicide, inconsistent with known facts about the crime scene. So he's providing in his confessions facts that don't align with what we know to be true of the crime scene. So how is he actually confessing if he's confessing to things that didn't actually happen? Periods of not sleeping for days, hence the lights on. I wouldn't even be surprised if they had people like talking to him all the time so that he couldn't get sleep. And that's what those people were there for too, was to keep him awake 24 hours of the day so that he couldn't sleep. If you have someone stationed on him 24 hours a day and you tell them they're supposed to observe, but you're also supposed to talk to them to keep them awake, it's really not difficult to do. If you have like a 4-hour window or a 2-hour window and then they keep rotating people in and out, it's just awful to think about what he's been through so far. So already suffering from a bona fide mental health condition, they kept him away from his wife, kid, family, weakened to a point where he could just slip into like a dissociative state of mind where he's nothing's as he believes it is, nothing is as it is, because he's constantly having people tell him it's something else, that something else is going on. So these behaviors were manifested through verbal confessions that he may have been drugged, verbal confessions to the double homicide that were inconsistent with known facts about the crime scene, periods of not sleeping for days, paranoia, stripping off his clothes, drinking toilet water, covering himself with and eating his own feces, and many other socially unacceptable behaviors. Let that sink in. On the occasion that Alan confessed to SAing those 2 young girls and shooting them in the back, on one occasion he confessed to this. On another occasion he professed his sorrow for SAing Abby and Libby and others which he specifically named. Okay, so he named other people as well. Are they trying to get him on other crimes, maybe? Maybe they're trying to pin some other crimes that have been unsolved or something. I don't know. On another occasion, no, these facts are known to be falsities, none of which were supported by the autopsy findings by Dr. Roland Kaur as to the cause of the end of the girls' lives, and unsupported by the absence of any evidence that either one of the girls were SA'd near or before the time of their lives being taken. At the time Alan uttered these falsities, the state's actors were in the ready position with pen in hand, documenting the entirety of Alan's mental and physical deterioration and actions stemming therefrom. The infringements on Alan's legal rights didn't stop there. Inmate companions then spread the good word of Alan's confessions to inmates in general population at Westville, prompting those inmates to share the information with the respective family members in the public. So just you're spreading it far and wide now, because once it gets through the jail system, it's going to get out and, keep going. So proof of the leaks were offered up by the state in the form of audio recorded interviews and accompanying transcripts, and included in large volumes of discovery dumps received by the defense in the recent past. So they're still getting discovery dumps thrown at them at the very last minute, even though they just got like all their stuff back at them with more than they ever had before, because they got reassigned back in, I think it was January. They got the discovery back, but now we're going to trial, and we got the speedy trial in place, and I don't know how the defense team is going to get through it all, but they're going to. try to get through everything, all these large volumes of everything that the state seems to try to bury all the important stuff under hidden names and different ways to bury it. So whatever. All right, so however, neither Allen nor his legal team are aware of any self-reporting of said leaks by the defense. Wait, did I? Yeah, proof of these leaks were offered up by the state in audio form. However, neither Allen nor his legal team were aware of these leaks by the state to the defense or the state to the court, despite the fact that the state was aware of this information as early as May 12, 2023, when Patton and Elliott were interviewed by law enforcement investigators. So Lacey Patton Jr., an inmate, and Jason Elliott, also an inmate. These two were interviewed by law enforcement investigators. Allen's due process rights have been all but ignored. It is also established that the 14th Amendment forbids fundamental unfairness in the use of evidence, whether true or untrue. As important as it is that persons who have committed crimes be convicted, there are considerations that transcend the question of guilt or innocence. Thus, in cases involving involuntary confessions, the court enforces the strongly felt attitude of our society that important human values are sacrificed where an agency of the government, in the course of securing a conviction, wrings a confession out of an accused against his will. So all of that. Court. Okay. Anyways, this insistence upon putting the government to the task of proving guilt by means other than inquisition was engendered by historical abuses which are quite familiar. The truth or falsity of Allen's statements are of no consequence to this analysis. Allen has been treated unlike any other pretrial detainee in Indiana in recent history. We need the ACLU involved in this, I think. The ACLU and other organizations need to start, looking into this and taking it up, because this is egregious, the way that they are treating Allen, and it went on for so long as it did. And we still don't understand the full complexity of what's going on to him now in Wabash facility where he's at currently, because we were told that that place wasn't safe either. So I don't know. All right, so the truth or falsity doesn't matter. The methodology employed by the justice system is one of first impression, and therefore the circumstances created by this methodology should not be part of any reconsideration of Allen's guilt or innocence. The system of pretrial detention employed against Allen runs afoul of the 5th and 6th Amendments of the United States Constitution and Article 1, Section 14 of the Indiana Constitution. It is for those reasons any and all incriminating statements made by Allen while incarcerated should be suppressed. What do you think? I think they made a good argument as to suppressing the statements. However, I don't think Judge Cole is going to do it. That's just my opinion, and that's just how she's been ruling. Like I said, I think she might just deny it without hearing, although they are asking specifically for a pretrial hearing to determine if the statements were given in a voluntary nature. So we'll see if anything comes of that. And then 2, to suppress that evidence. So that is the motion and all the case law behind why they should suppress Richard Allen's confessions. So they are, obviously, the defense is going with these are coerced confessions that he made under duress, and they should be thrown out. If you were Judge Gall, would you throw them out? Do you think Judge Gall is... Okay, if you were the judge, not Judge Gall, but if you were the judge in this case, would you throw out Allen's confessions based on this motion? Or, and the state's going to come back and object to them throwing it out, but we'll see what happens. I don't know. I just don't see Judge Gull granting anything for the defense at all. I really think that the ACLU and other organizations that take up human rights can start getting together, looking into this, becoming a part of it, and, standing up for human rights, for what is right. And we really need to stop false confessions. I really started this this channel because of false confessions and wrongful convictions. Just really fascinate me. I mean, true crime in and of itself has always fascinated me, but this particular part of it, and how one bad actor or just a couple bad actors make everything corrupt, and it spoils the fruit of the poisonous tree. It is having corrupt people on the inside trying to get confessions out of Alan. Everything needs to be thrown out. I'm sorry, but it really does. His statements specifically, but he really should be released or put into a county jail, but they're not doing it. So I don't know. Let me know your thoughts below, what you think about this case, what you think about Judge Gull, what you think about Richard Allen and his chances of getting a conviction or, some kind of vindication that, maybe he'll be cleared in trial if this goes to trial. It seems like we are, but what do you think? Let me know in the comments below. I really appreciate you guys watching and being here and going on this crazy ride of Delphi with me, because it is crazy. So I thank you so much for watching, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.